Court is calling 2025 CR 005952, State versus Frank Garza. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Donald Wilson for Mr. Garza.
And are you Mr. Garza?
I am.
Counsel, have you received all discovery and did you review that with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, I see in the notes that there was a competency evaluation done.
Yes, Your Honor. It was, and it came back that he is competent, and I agree with that.
All right, and he's already been deemed competent by that court and that judge?
That's correct.
Welcome back to Judge Point. If you love real courtroom drama, subscribe now so you don't miss our case breakdowns. Today's case is State of Texas versus Frank Garza. A competency evaluation confirmed Garza was fit to stand trial, and the state agreed to proceed on a lesser included charge: attempted unlawful possession of a firearm by a felon. The courtroom is tense as Garza prepares to plead, knowing his past felony conviction makes the stakes high. What unfolds is a clash between strict law and questions of fairness.
All right, thank you. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding for the lesser included attempted possession to make this a third-degree felony.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of attempted unlawfully carrying a weapon with a felony conviction?
The hearing opened with routine questions. Garza confirmed he reviewed the indictment, understood the charges, and waived the formal reading. The state reduced the charge to a third-degree felony, carrying a punishment range of 2 to 10 years. The judge carefully explained Garza's rights: the right to a jury trial, to confront witnesses, and to remain silent. Garza knowingly waived those rights and chose to proceed with a plea. The tone was formal, but the real tension would come later, when the court wrestled with whether justice matched the facts.
As a third-degree felony, the range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
Garza was asked if anyone threatened or coerced him into pleading, and he firmly said no. He also denied receiving promises outside of the plea deal. The judge confirmed he was satisfied with his lawyer, a U.S. citizen, and understood the punishment range. With that, the plea bargain came into focus: 2 years in prison, forfeiture of the firearm, and waiver of appeal rights. On paper, everything was clear and lawful, but what Garza's attorney said next would shift the entire conversation from legal procedure to moral fairness.
Citizen. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted unlawful carrying of a weapon with a felony conviction. They're asking that your punishment be assessed at 2 years in the prison and you to forfeit the firearm. Did you understand that to be the plea?
Ma'am.
Defense?
Yes, it is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places? I'm sorry?
Defense counsel painted a different picture. Garza had not been trying to conceal the firearm or use it. Instead, he claimed he found the gun downtown under a bridge. Concerned, Garza picked it up and called 911 to report it. While still on the phone, he was spotted by campus security on UTSA property. Because of his felony record, simply holding the weapon, even briefly, made him guilty under the law. But his lawyer stressed the intent. Garza was not arming himself. He was trying to do the right thing.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
Okay.
All right, state two may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any?
The judge listened closely, acknowledging the dilemma. Technically, the law made Garza guilty. He was a felon in possession of a weapon. But was this what the law was meant for? The judge openly questioned whether prosecuting someone for trying to turn in a gun served justice. Picking up a weapon to protect the public seemed far different from carrying one to commit a crime. The court admitted the police report didn't show evidence of Garza's claim, but the missing 911 call recording might hold the truth.
Witnesses the state would call and the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentence?
The absence of the 911 call became a pivotal issue. Both sides confirmed they had requested it, but it had not been provided. Without it, Garza's version of events couldn't be corroborated. The state admitted that while the elements of the crime were met, the circumstances raised doubts. Still, they were willing to proceed on the lesser charge and minimum punishment. The judge faced a difficult question. Should Garza be sentenced strictly by the book, or should the court delay in search of missing evidence that might change everything?
With a gun on property, and that's what led to this. We've looked at pursuing this to a trial and all that, but Mr. Garza has been locked up for more than 6 months, and he has elected to take this plea. He was in possession. He is a convicted felon, so it meets the technical, allegations. But that was the reason that Mr. Garza has chosen to move forward with this case.
So a gun was discovered, and he was calling the police to turn it in.
He took it. It was during the church under the bridge. He
Mhm.
went to use a phone from one of them, which is on the UTSA property, and was, as I understand.
The judge spelled out the dilemma directly to Garza. On paper, he was guilty. Felons cannot possess weapons. But if his story was true, punishing him for trying to turn in a gun didn't fit the law's purpose. To the court, the judge explained, that's not what this law was meant for. The judge emphasized the danger of leaving a firearm abandoned under a bridge where anyone, even a child, could have picked it up. Garza's decision to secure it might have prevented harm, but it landed him in court.
On the phone when UTSA security saw him and came over, and here we are.
Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not. So I don't know if there's proof of what he's saying or not. Based upon what I'm reading, it's not what's being said. I don't see it in the police report. So.
And with the nature of the offense and the people around.
The judge outlined Garza's choices. He could accept 2 years immediately or wait 2 weeks while the state tried again to obtain the 911 recording. Either way, Garza would receive credit for time served. The risk was simple. If the 911 call confirmed his story, the state might reconsider his punishment. If not, he would still face the 2-year deal already on the table. The judge reminded him that this was his decision alone. No one could force him. It was a gamble between certainty and potential fairness.
The witnesses, it's a challenge. That's what the defense is faced with, and that's the reason Mr. Garza has elected to.
And I'm assuming that's the reason why the state is proceeding on the lesser included.
As well as the minimum.
All right. Then the court will find you guilty of the lesser included offense. The court. All right. So here's my thing. We can go off the record. I understand why the state would proceed.
Garza hesitated, struggling to grasp the complex legal strategy. "If I have no other choice, then yeah," he said softly. But the judge corrected him. There was a choice. Either take the guaranteed 2 years now or delay and hope the missing evidence surfaced. Defense counsel explained further the state might change its position if the 911 tape proved Garza's version of events. The courtroom quieted as Garza weighed his options, caught between the rigid letter of the law and a slim chance for vindication.
And it appears that there was the gun didn't have any, wasn't loaded or anything.
Your Honor, you do speak to a good point. If there is proof, there has been requests for things that have been alluded in the police report, things that would have corroborated.
Mhm.
The state has not been able to receive those things. There have been discussion with defense.
Mhm.
The state understands if it came to a he said, we understand and believe the report. Things have been requested that we don't have. And
who would have these things?
The judge reminded everyone of the stakes. The law forbids felons from possessing weapons, especially those with family violence convictions. That was the reason for such strict restrictions. But in Garza's case, intent mattered. If he truly was trying to turn the gun in, punishing him as if he were arming himself seemed unjust. The judge emphasized again that the law's spirit was to prevent violence, not to penalize people for preventing harm. This moral tension transformed what seemed like a routine plea hearing into a profound debate about justice.
Or if you want to wait, I can not sentence him today and they can see about the 911 call.
And Judge, I'll talk to Mr. Garza. This case was set for a couple of weeks from now. Mr.
Mhm.
Garza has asked me to push it up to move the case.
So, Mr. Garza, do you understand what's going on?
Just a little bit.
All right, so here's the thing. You're not allowed to possess any weapons if you have a felony conviction. And then there's some things, if you have a family violence, you're not, an affirmative finding of family violence, you're not allowed to possess any weapons either. And that's what this law is.
The defense reiterated that Garza's mental health issues, prior injuries, and long pre-trial detention shaped his decision to plead. He had already been jailed more than 6 months. With or without the 911 call, he had chosen to avoid trial and accept the deal. But the judge wasn't content with legal formality alone. Justice, the court argued, meant more than checking legal boxes. If there was evidence supporting Garza's account, it deserved to be considered before finalizing punishment. The case was no longer just about one man. It was about fairness itself.
Comes up to him and he's like, yes, I do have this weapon, and yes, you may search my backpack and everything. So you can discuss it with your attorney if you want. We can recall it back in 2 weeks. Here's the thing. If it turns out that they can't get the 911 call and you still want to go forward with the 2 years, you'll have the 2 years and you'll get credit. So if we come back in 2 weeks and you end up getting 2 years, guess what? You're still going to get credit for the time that you were waiting for those 2 weeks. It's just you'll be at the Bexar County Jail and not at the prison. It's completely up to you. But for the court, I don't.
As the court recessed, the judge acknowledged why the state pursued the lesser charge: practicality, efficiency, and uncertainty over the missing evidence. Yet the judge admitted openly, If somebody finds a gun, picks it up, and calls police to turn it in, is that what this law was meant for? The question hung heavy in the courtroom. Both sides knew the law's letter was satisfied, but its spirit was in dispute. For Garza, the outcome hinged not on guilt or innocence, but on whether the system could balance law with justice.
And I could be wrong. If I'm wrong, somebody correct me. I don't think that's the spirit of that law. So,
Judge, I'm in agreement with you. It's up to Mr. Garza.
Okay, so can you explain that a little better to me?
all right, so the state has offered you 2 years.
Okay.
I will follow that 2 years if the state, if they go and they're not able to get the 911 call because they say they've been trying to get the 911 call. If they are unable to get the 911 call, you'll still have the 2 years. So your waiting 2 weeks is not going to change your position.
In the end, the decision was Garza's. Accept 2 years immediately or wait 2 weeks for possible evidence that might not even exist. The judge assured him waiting would not worsen his punishment. He would still get credit for time served. The stakes were clear, yet the uncertainty weighed heavily. Garza, weary from months behind bars, struggled to choose between finality and hope. The moment captured the core dilemma of courtroom justice. Sometimes the law is absolute, but fairness demands a second look.
No, I mean, you have choices. These are your choices. I can sentence you to 2 years today, or we can see if the state can find if the state receives, I don't want to say fine, if the state receives the 911 call, then if the state receives the 911 call, they may decide to do something different than what they're doing now, which may be in your favor. But at the end of the day, worst case scenario, you're sentenced to 2 years.
Okay.
Wait 2 weeks. Well, it's up to you, but it's.
You want to discuss it with him in the box and then just let me know? All right, thank you.
The case of Frank Garza highlights the thin line between legal guilt and moral innocence. By law, a felon with a gun is guilty, no exceptions. But Garza's story raised a deeper question. Should intent matter when justice is at stake? The missing 911 call could have tipped the scales, but without it, the truth remained unclear. On Judge Point, we explore these gripping courtroom dramas that challenge not just the law, but our sense of right and wrong. Like this video, subscribe now and join us for the next case breakdown.